United States come before the court as the state of Sylvia Johnson versus Ohio Department of Job and Family Services. Will one of you do a favor to the court and stop that thing from it's driving me crazy?
I'm so
We need to do
sorry.
something.
I did. I'm so sorry.
No, everybody does it. It has a mind of its own, it takes over. Any rate, as I said, this is State of Johnson versus Ohio Department of Job and Family Services. Both sides will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. I don't think this is relevant here, but we do videotape, and you are asked not to mention the names of any victims or any children. We always use initials or refer to them in the third person, like the child or something. Also, please stay behind the podium and keep your voice up, which I am guilty of not keeping my voice up, so I will admonish you and I'll try to do the same thing. Okay, how much time would you like to reserve?
5 minutes, Your Honor.
Thank you. And the monitor has the time. All you need to know is just look at the top circle.
Okay, great.
You may proceed, I'm sorry.
Thank you. Good afternoon. May it please the court, my name is Lisa Larmer, and I represent the appellant, the estate of Sylvia Johnson. This appeal concerns the denial of long-term care Medicaid benefits for Sylvia Johnson. The denial was upheld by the administrative appeal decision and also the lower court's decision in this matter. To simplify the situation, what happened was the Summit County JFS essentially dropped the ball in every possible way, in my personal opinion. What happened was they never even acknowledged her first application. To take you back to 2016, Ms. Johnson, she was a 72-year-old woman in need of 24-hour skilled nursing care prior to her death. And the facility submitted a Medicaid application on her behalf. The first application was never acknowledged, and a second application had to be submitted. Unfortunately, Ms. Johnson had passed away right around that time, and it was at that point, after 30 days after she had passed, after the application had been submitted, when they finally opened the Medicaid case, they sent a verification list. At that point, they started gathering the information that was required of her. The Ohio Administrative Code does require that the agency determine initial eligibility, including obtaining verifications within 30 days from the date of the Medicaid application. The federal requirement is 45 days. So at this point, we're definitely after the 30 days. So it was roughly December of 2016 that the agency received approximately 250 pages of bank statements to go through. This is what they had requested. So it takes them until roughly July of 2017, for no good reason, to process these bank statements. So they had requested, in return, verifications, questioning 91 transactions of Ms. Johnson's. So at this point, you have to assume that they're doing their 5-year look back, where they're questioning to see if she had transferred any assets or resources for less than fair market value. Did she give away any money, etc. So of those 91 transactions, only 8 of them were withdrawals. So in my mind, that's pretty questionable anyway. So the 8 withdrawals, they total $5,600. Unfortunately, at that point, with the significant delay, and with Ms. Johnson being deceased, despite Legacy Places, the facility's best efforts, and signing a verification, for the bank to provide information, verifications were not submitted back to the agency. So that was the remaining piece. So apparently they believed that they denied her Medicaid application. However, no notice of action was ever issued by the agency denying her application. Instead, they issued a notice of action approving her for 1 month of the 4-month period that was requested. Essentially, when her application was submitted, it requested 3 months of retro benefits plus ongoing. So they submitted a notice, and this was in June of 2017, when she had passed in November of 2016, saying you're approved for November 2016, but we're going to stop your benefits at the end of June 2017 because you had passed away. So apparently they approved November 2016 in error. Everything about this case, it really is unfortunate, in my opinion. But, so essentially, Ohio, I'm sorry.
I'm still confused of why the issue seems to be verification. What was impossible? It sounds like in the brief it was impossible because of the time lapse. I don't understand how it's impossible to prove resources after something.
It wasn't, Your Honor. That's what's so bad about this decision is I believe that this case should go back down to the agency because it's not impossible in this case to prove the resources.
But the parties ultimately did not. You're saying that.
According to the agency, but they have the bank statements. They know her money, they know what she had. They're saying you didn't verify these transactions, and we're saying you're not eligible because the OAC says that you have to answer our questions, which realistically the agency can say to any one of us, tell me what you spent all your money on in the last 5 years. I mean, essentially that's why, and the record reflects that's why she was denied. So it's not impossible, and that's why I believe that this application should be reopened, Your Honor.
So you're saying, and I think this is a little different than what was argued in the briefs, you're saying that they had the information.
Your Honor, they have all of the bank statements. What they don't have, they submitted a list, which is in the record on page 140. They submitted a list of transactions to Legacy Place, and this was submitted approximately 8 to 9 months after Ms. Johnson's death. And it says, what were all these transactions for? What were they for? And she was deceased, and her family was unwilling or didn't know what these transactions were for. But I will tell you what these bank statements do show as well, is that she was receiving $891 per month in Social Security. This was a low-income individual, which was the type of person that Medicaid is intended to benefit.
And so did those documents show that she didn't own any property, no property had been transferred, anything like that?
Your Honor, the record does reflect that the only holdup is these transactions in this verification list. In the notes from the agency, which are part of the record, it does say there's a journal entry, etc., page 124 in the record, where they're saying we cannot approve without a response to these transactions.
So you're requesting that because the Summit County Job and Family Services did so many things errantly, and that's verifiable, that should get a second bite at the apple in providing those verifications.
No, I'm saying they have the information. I think if they're questioning these withdrawals, which they're over a period of, maybe a year or two, roughly. If they're questioning them, realistically, what an agency will do is give like a penalty. They'll say, okay, well, we're gonna approve you, to me, she's eligible. We'll approve you and you'll have a penalty period.
But isn't there a good reason for those verifications, that parties don't spend down the assets to qualify for Medicaid?
Absolutely.
So if those verifications are missing, how are they going to calculate what the true resources are? And that assets aren't being spent down?
Absolutely, Your Honor, but I think in this situation, this 91, transactions with only 9 being withdrawals, which is exactly what is in the state's brief, that they're saying we need to verify these, these transfers, or, they're actually looking at withdrawals. If it's only $5,600 with this extremely low income lady, there has to be some sort of reasonableness standard. If she's supposed to have a penalty, then so be it. It's supposed to go back to her, if she can't provide proof of the, what were these, there's suspect, then you get the penalty. And she's deceased. One of our arguments is if they had timely processed and questioned her, it doesn't take 8 months to do it for bank statements. If they had.
Counselor, you are in your rebuttal time. If you want to proceed, that's fine, but I just wanted you to know that.
I will just take maybe 1 more minute. If they had timely processed to begin with, they could have questioned Ms. Johnson herself. Thank you.
You may proceed.
Thank you, Your Honors. Teresa Deer Summer, representing ODJFS. We're asking this court to affirm the decision of the Common Police Court, which upheld the denial of Ms. Johnson's application. I'd like to explain the difference between looking at one's resources and looking at improper transfers, because there is that distinction here. So there is an individual resource limit. At the time, an individual couldn't have more than $2,000 in resources. But in addition to that, there's what's known as the 5-year look-back period, where the agency looks through 5 years of financial transactions looking for what are called improper transfers, which by definition, in general, are transfers of property for less than their fair market value for the purpose of obtaining Medicaid eligibility. So that's what's at issue here. It's not what was the amount of her resources. It's here are the financial transactions that your bank records are showing us, and we need additional information as to what they are to show that they are or are not improper transfers that affect whether you're eligible and the timing of that eligibility. It is not just the withdrawals that are relevant. The deposits obviously indicate the receipt of money, which could indicate the sale of property. The record isn't, there's no evidence as to what the deposits or withdrawals were for, but the financial transactions, all 91 of them are relevant, not just the 8 withdrawals. They also,
Counsel, let me interrupt you. In regard to that, though, I assume that's in the record, right?
which ones are relevant?
No, I assume it's in the record, the requests for the 91 items that ODGFS asked for.
Yes.
Okay. So what I'm hearing opposing side say is those 91 transactions may generically be relevant, but they were not relevant in this case because if you looked at all the transactions, it had nothing to do with her eligibility.
The transactions themselves don't really give information. They are not regular monthly deposits, and they're quite high dollar values. The vast majority of them are over $1,000 in deposits, some are over $2,000 or $3,000. a few days apart, a week apart. There's not a consistency to them. You can't just, oh, these are easily identifiable as Social Security payments. These are easily identifiable as payments that, regular payments that she would, either obligations or deposits that she would receive. There's not a consistency to the dollar amounts or the dates. It's not clear just from the list of transactions that they're not improper transfers.
Thank you.
And because they weren't able to receive any verification of those resources, they weren't, and the transfer specifically to determine whether or not they were improper, the county was unable to determine that Ms. Johnson was eligible for Medicaid.
And we're talking about 3 months here, right?
Yes,
3 months of inpatient care at a nursing facility.
yes.
So did the agency, the Ohio Department of Job and Family Services, actually issue a denial?
So it is the county departments that actually issue the
Okay.
notices,
Well,
not the state.
I'm sorry, so
But-
did Summit County issue denial?
They did not, no. They issued 2 notices. One was granting benefits for the month of November of 2016, and the other, issued at the same time, was discontinuing benefits, I believe effective January of 2017, because Ms. Johnson had died. Realistically, any benefits would have terminated at her death anyway, so there wasn't any coverage from November to that January date.
It's just
anyway.
those 3 months, right?
Yes, because you can get 3 months of retroactive coverage, so it's that retroactive coverage that's at issue here. The actual state hearing request that Ms. Johnson's representative submitted, they termed as an inaction appeal. You can request a state hearing to challenge the agency's action or inaction. They basically were questioning those 3 months of retro coverage, so that is what the scope of the state hearing was. That was made clear from the record, from the transcript of proceedings, that it was understood that the state hearing was going to address her eligibility for those 3 months at issue, August, September, October, I believe, of 2016. But there was not a formal denial notice issued for her.
And that's what I'm trying to figure out, because isn't the local agency required by law to issue a denial?
They are, they are. The record doesn't have an explanation for some of the agency errors that were made in this case. As a practical matter, there wasn't any prejudice resulting from the failure to issue a denial notice because Ms. Johnson, through her representatives, was able to have a state hearing regarding the denial of her application. So had a denial notice been issued, the outcome would have been the same. She could have requested a state hearing to challenge that, which is what happened here. There wasn't any argument made below that the notices themselves were deficient such that her due process rights were impacted, and there wasn't any resulting prejudice because the scope of the hearing was still the same. And the issue really is that without an affirmative finding that Ms. Johnson is eligible for Medicaid, Ohio law prohibited the county from approving her for benefits. That's in Administrative Code, Section 5160:1-2-01I. That position has also been upheld by other appellate courts in the state. Our brief cites specifically to the 7th and 8th districts, which apply that rule in finding that there isn't any way, even as a remedy for agency error, of approving Medicaid benefits. The law is explicit that even a delay in processing or agency error can't be the basis for an award of benefits, that eligibility has to be shown. And the record here just doesn't enable the county to make an affirmative determination of eligibility for Ms. Johnson.
Of course, it is very difficult after someone passes away.
Yeah, I imagine it could be, yes, that would certainly make things more challenging. The county, the only application that the county has a record of receiving was submitted, I believe, one day after, either within 1 day of Ms. Johnson's passing, in November of 2016. Within 5 days of receiving that application, the county submitted their first request for financial documents. And it took about a month, it was sometime in December, that they received 257 pages of documents back. So the record, it's not, and then once they went through those documents, they came back with the 91 specific transactions. So given that timeline, it's not clear from the record that even if the county had processed the application that Ms. Johnson's representatives say they submitted in October, it's not clear that Ms. Johnson would have been alive when the county was able to go through the individual transactions.
So what is the procedure? I don't remember from the briefs if you mentioned it, so I apologize. But what is the procedure, and just like you said, if you get like thousands of pages and you cannot make the determination in 30 days, what's the procedure by statute that the agency is allowed to do? Are they allowed to request additional time? Are they, what do you do?
The rule does obligate the agency to process an application. At the time, I believe it was within 45, either 30 or 45 days. Sometime, the county would have had the option of just denying the application in that time frame, saying they didn't have the financial documentation that it needed to support eligibility and denied on that basis. In this case, the county, I wouldn't say that it asked for an extension. I suppose it just gave itself additional time and sent out additional verifications to see if it could get the financial documentation it needed to give her representatives additional time to establish eligibility. Because a Medicaid applicant is always free to reapply for Medicaid coverage, but you're limited to how far you can go back. So if an initial application is submitted in November, it's denied in December for insufficient financial documentation, and it takes until April for them to have that information gathered and reapply. The most coverage that applicant could get would be April and then back 3 months, January, February, March. You would lose from when the application was submitted in November and the 3 months prior to that without any way of going back and getting coverage for that time. So it can be to the applicant's advantage to have a county extend the deadline, give additional time to provide those verifications, because you don't lose your application date.
Of course, you could do a conditional approval or a conditional denial, right?
There is a provision, I don't remember the rule citation, there is a provision providing for conditional approval if, in a certain circumstance, I think if there isn't someone available to help gather resources, or if they've asked for assistance gathering resources, I don't believe the specifics of that rule had been invoked here, and even then, the eligibility is later determined based on financial documentations later received. I think they have to evaluate it based on the information known to them at the time. I'm sorry, I don't have that rule language in front of me. There is some provision for it in certain circumstances, though. I don't believe that would apply here. The last thing I wanted to touch on was the third assignment of errors claim that Ms. Johnson's due process rights were violated at the state hearing because a particular witness wasn't made available. An individual in the state hearing has the ability to subpoena someone to testify at the state hearing. Ms. Johnson's representative certainly had the ability to subpoena the caseworker that they wanted to be present. They did not do that. They had an informal request for her to be present at the hearing in their state hearing request, but that does not compel the county to provide the particular witness they wanted. There was no objection raised at the state hearing regarding the witness that the county did provide. Ms. Johnson's attorney had the ability to cross-examine that witness. They had a full opportunity to participate in the hearing, and as the lower court found, there wasn't any due process violation from the failure to have a caseworker testify, absent a subpoena compelling her attendance.
At this hearing, maybe I misread, but isn't there some kind of regulation or administrative code provision that the individual that processed that is supposed to be at the hearing?
I'm not aware of that requirement. In this case, the individual that testified for the county stated that she was familiar with the application. She was not the caseworker who worked on it, but she had familiarized herself with the application prior to her testimony.
Thank you.
If there are no further questions, we ask that you affirm.
Thank you.
Thank you.
We have 4.5 minutes.
In this case, I would just like to bring to the court's attention, if every Medicaid application was treated the way that Ms. Johnson's was, that Medicaid would rarely be granted. Between the processing delay and the inability to follow the processing guidelines and the regulations, they would never be able to obtain the verifications required while an applicant is actually living. I mean, most of the time, folks that apply for long-term care Medicaid are actually in facilities, unfortunately, on their deathbed, as was Ms. Johnson. The regulations, the strict timelines actually exist for a reason. The lower court's decision, they basically said, right, they did not follow the regulations. They did not follow the strict guidelines here, but the court seemed frustrated that there was not anything that they could do about it. But I believe that there is something that we can do here. I believe that in this case, it should go back down to the agency. I think the lower court should be reversed here, and I think that Ms. Johnson's application should be reopened. I believe that the agency does have enough to process her application. I think that the verifications that have been received, in fact, if she had these deposits, they were able to verify the resources that she had during the relevant period. As I indicated, $891 per month in Social Security.
Is your argument that the verifications provided are enough, or that you should be allowed to go back and provide the verifications they asked for?
I believe that what was provided is enough.
But isn't Medicaid a government benefit program based on need?
It is.
So how do you start giving out government benefits without verification that it's a true need, or that there wasn't some fraud or spending down of assets?
I don't think that they processed it to the extent, I don't believe that I don't know how to say this, Your Honor. I think that Summit County took the easy way out in every turn on this case. Once they found out that she had died, they even stopped processing the application. That's in the record. So I think that requesting verification on 91 transactions was egregious. I think that if they want to impose a penalty as far as coverage, some sort of penalty, but find that she's eligible, I think that just affirming what happened here, even though they never even issued a formal denial of benefits, I think that it would be in violation of the law, Your Honor. Even if they end up coming to the same conclusion, I think that allowing what happened to stand is in violation of the law, and it can't stand.
So if we were to reverse, you would want us to reverse to the agency and say, make a determination of denial or approval based on solely the documentation that you have.
That's correct, Your Honor, because there's no additional information to be had at this point. The poor woman has been deceased since 2016. That's all I have.
Counsel, let me ask you both. I know this is a government entity and so forth, and I understand, there are specific regulations and everything, but I look at our docket, it says that there was no mediation that was ever conducted in this. Is that true, that the parties have not tried to mediate this?
I believe so. Unfortunately, I literally have case for 2 weeks.
Oh, geez.
I know, Your Honor, we had an attorney leave and this was given to me, so.
I have been on this case since the original appeal, and I don't recall any mediation efforts.
Would you be adverse to the mediator, our mediator reaching out? He does a very good job.
We have had this week some initial settlement discussions. I personally don't think that formal mediation would be necessary. I think that kind of informal process would tell us whether or not we'd be able to agree to something.
Well, especially if you're looking at settlement, let's have the mediator reach out to you and then you can decide from there, okay? All right, thank you.
Okay, thank you, I appreciate it.
All right, and that's the last argument of the day.